go ahead and do that.
This meeting is being recorded.
Okay, I see my dear friend Maggie Kinnear. It's so good to see you. So it is 12:05. I got a nice text message that just came in. Thank you so much.
Voice irritating to you? Yeah. I'm trying to turn it down.
Okay, and we've got to mute everybody else. There's a way for us to do it on our end. I'm not sure exactly, but I'll just introduce myself really quickly to you. I'm Mariel Risner-Sivley. I'm relatively new here. I've been here since September. It's such a pleasure to be here and to work in the area of housing with you all. There were 95 people registered for the Zoom. So clearly this is a matter of precedence and importance to the work that you're doing. I already knew that. That is no surprise to me. That's why I'm here, to help further that. And so before I pass over to Maggie, I just want to make you aware of just two things to put on your radar. So the first thing is our Motel to Home program. I'm excited to announce to you that we got awarded some funding yesterday, actually, to expand it in the metro area to 13 counties in the metro area. So you will be receiving information from me about this. We really want you to participate in your conference. It's a longer term program. Generally, the financing per household for this program is between $2,000 and $4,000 per household, depending on need. And we have funding for that now. Not up to $4,000, a little bit less than that, but a significant amount per household to get them out of an extended stay motel, couch surfing, living in their vehicle. And we could use your caseworker volunteering for that. So in the new year, we're going to be doing volunteer trainings on that. So that is really good news that I'm excited to share with you all. Also, we were awarded funding in Cobb County for a short-term assistance program. So if you're in Cobb, we're going to put information on the member website for you about that and share information with you guys directly about that. Outside of these areas, and I'll share those counties, I'll put it in the chat. These 13 counties where we have funding for the program, we are continuing to apply for funding for the rest of the state of Georgia, so that we will be able to bring this program across the whole state where you want to be a volunteer in it. So that's a continued effort, and I feel confident that we'll have success in it. So the support for the metro area is coming from the United Way of Greater Atlanta. And if you have a connection with your United Way in your area, we already have a great touchstone with them, and it would be great to just really further that. So I'm just really excited to share that with you guys at the outset of this meeting. Landlord engagement is a big piece of that, because these are families looking for units that are affordable in the private market. So if you're not interested in doing the motel to home piece, you might be interested in helping us engage a landlord to house the families. So we're also going to be doing a landlord engagement program that provides support for the landlords. So look out for that information as well. Okay, so now the heart of why we're here today. You guys are very involved in supporting families on a weekly, daily, nightly basis. And there's such a need for good information about what happens when they are facing an eviction or even in the midst of a dispossessory action. And so my colleague and friend Maggie Kinnear from Atlanta Legal Aid is here with us today. She has a PowerPoint, so she needs co-host Zoom powers as well. And I've known Maggie for a very long time. She attended Emory for her undergrad and has maintained a leadership role with her sorority there, Kappa Kappa Gamma, since attending there. She obtained her Juris Doctor from Georgetown University Law Center, and she's been with Atlanta Legal Aid since 2000. She is the director of the tenant hotline there, And she is an expert in this area. And most importantly, in her career, she has helped thousands of people. So she's here to teach us about the eviction process. She's here to talk to us about the newly established rights of folks who are residing in motels that we're serving, and to answer your questions. And I'm going to pass over to her.
Thank you for that introduction, Marielle. I still don't have screen sharing capabilities, so I don't know if we can get that going. But while I'm waiting, I will put a plug in for another organization that I'm involved in called Paws Between Homes. Paws as in animal paws. They foster animals for people who are between homes, and so that they don't have to be surrendered to local shelters. And it's a really great program, if I do say so myself. I currently have 2 foster kitties who came together as a pair, and I'm pleased to say that the 2 boys, my cat and the other one of the other cats, have become good buds. So it's an exciting day all around. Okay, I think
That is
I can
awesome.
share my screen now. Yeah, it was nice. It was a nice day. Can everyone see my screen?
Yes, we can see it.
Great. So as Marielle said in her lovely introduction, I am a tenant attorney at the Atlanta Legal Aid Society. Just going to talk with you a little bit today about housing law in Georgia. Let me start this. There we go. Okay. And so this is just a little bit of information about Atlanta Legal Aid. We are coming up on our 100-year anniversary, and we're in the 5 sort of main metro counties: Fulton, DeKalb, Cobb, Gwinnett, and Clayton, as well as in the children's hospitals in the area. And we do a wide variety of cases: family law, consumer, all kinds of public benefits. But in the landlord-tenant arena, we represent tenants. There are obviously a lot of landlords who can use legal assistance too, but there are also a lot of lawyers who assist landlords. And so we try to focus on the tenants and make sure that their voices get a fair shake as often as we can. The other thing I will just advise you of is this is meant to be informational. Only lawyers are allowed to give legal advice. So if you're not sure when you're talking to someone, if you're veering into legal advice, please feel free to refer them to legal aid. Our contact information is on the last page of this presentation. It's our website, which has an online application for intake, as well as the main phone number. The best way for people to get to talk to someone as soon as possible is to go through our intake process. And so please feel free to refer someone if you think that they need to talk to an attorney about what's going on with them. Start with some basics. And I think, I know there are probably some questions that are going to come up in the chat. Please feel free to come in there or hold your questions. I'll try to make sure we get to everybody if I don't answer your question during the presentation.
Good.
This is general information that I give to any tenant who calls us. Unfortunately, in Georgia, tenants really have to make sure that they are protecting themselves as much as possible. So always pay the rent, make sure they've got their paper trail if something happens, so that if they do end up having to go into court for an eviction or for some other reason, they have all of the information to be able to show the judge what happened. And this is just how Georgia defines the landlord-tenant relationship. It's great, vague legalese definition of a landlord-tenant relationship, but basically just means like somebody who is either the landowner or like manager, a management company, has the ability to give someone the right to use and enjoy the property, and that person decides, yes, I want to use and enjoy that property. I usually put this up here just to say not all housing situations are landlord-tenant relationships. I will talk about that a little bit further in a few minutes, but things like roommates, domestic partners, things like that, that's not a landlord-tenant relationship. They may have a landlord in common, but they themselves are not in a landlord-tenant relationship. Georgia recognizes basically 3 types of tenancies. And I know I'm running through this kind of fast, but I really want to focus on the eviction stuff that we'll get to later. I just want to give you a little background. First is just when there's a lease. Obviously, there's a start date, there's an end date. The lease includes the terms of the tenancy. A tenancy at will is when there's no, or a month-to-month tenancy as it's commonly known, there's no specified end date. That could happen either because there never was a written lease agreement. They just verbally agreed to this tenancy. That's fine under Georgia law. Or there was a lease, it ended, but the tenancy continued. In that case, the terms of the lease that they signed continue on a month-to-month basis. If they want to end the tenancy for just sort of general reasons, or the landlord wants to increase the rent or change one of the terms, landlord generally has to give a 60-day notice, and the tenant generally has to give a 30-day notice. Should always be in writing, even if it's not required to be. Go ahead, put it in writing. If there's cause to terminate, though, they don't necessarily have to give those notices. Also, if there was a lease agreement in writing, the tenant should go back and check, because that lease agreement may give different deadlines in terms of how much notice has to be given from either party. The tenancy at sufferance is just a kind of a fancy way, a legalese way of saying this person had the right to be in the property, but they don't anymore. So like if a lease is terminated and the tenancy is not continuing, but they stay anyway, that would be called a tenancy at sufferance. If during the term of a tenancy, or when there's a tenant in place, the property is sold, the new owner takes the property subject to the terms of the tenancy. So if I'm in the middle of a lease and my landlord sells the house to someone else, that other person has to honor my lease. If I'm a tenant at will and the person who owns the house sells it to someone else, that person takes it over with me as a tenant at will and has to give me a notice if they want me to move out. They can't come in and say, oh, well, I'm your landlord, now you have to sign a lease with me. No. We can sign a new lease if we both agree to, but I don't have to. That person has taken the property subject to my tenancy. If there's a foreclosure, it used to be that basically the person would be kind of out of luck. The tenant would, because the sale of the property, because it's in a regular sale, it's because it kind of behooves you to go and look at a property before you buy it. And in theory, if I'm going to buy a house, I might notice if there's a tenant living there if I go and look at it. Whereas in a foreclosure, it's just sold on the courthouse steps. The new owners for a long time didn't have to honor the tenancy. During the recession, there was a federal law called the Protecting Tenants at Foreclosure Act that at least put in place some protections, allowing for a 90-day notice to tenants before they could just be evicted, because a lot of tenants were finding out about the foreclosure when they were being served with eviction warrants, even though they've been paying the rent. And so they put that in place, also kind of requiring landlords, if it's really is a bona fide tenant, someone who's not a family member or the prior homeowner, to honor the lease agreement. That law actually expired, but they brought it back. So it exists again now, and it does offer protections to tenants like a 90-day notice and other things if they are in a house that's sold at foreclosure. Extended stay hotels are kind of the brave new world right now. I'm not directly involved in this case, but many of my colleagues are, and it's very exciting. And we've all had extended stay cases. They became we got quite a few. We've always had extended stay cases come in, but we got quite a few during the pandemic. A lot of people were having a lot of problems, sort of in this housing of last resort, being able to stay there during 2020, when it was very important to be able to be, even it's always important to be housed, but it was especially important at that time. So this case was appealed up to the Court of Appeals. And right now it's just, kind of go back a little bit. So we filed a case and basically asked the court to put an injunction on or stop on the extended stay evicting people. And the court granted that injunction, and that's what's been appealed. So they haven't really even gotten into the merits of the case yet. They're just appealing that injunction. But in doing that, they've been kind of arguing about whether landlord-tenant law applies to extended stays. And so far, the courts have found that, at least in certain circumstances, it does. Right now, and I'll get into some of those in a minute. Right now, though, this case is kind of in a weird posture, because the Court of Appeals agreed with us, upheld the injunction, and then the Efficiency Lodge appealed to the Georgia Supreme Court. They took the case. So at the moment, the order of the Court of Appeals kind of doesn't exist anymore, because the Supreme Court is going to enter an order. They are expecting to have oral arguments about the case sometime in March. And then I expect a decision will probably be made maybe in summer. And so we'll see what happens then. But the basis for the argument with extended stays is essentially, usually when you're talking about a hotel, you are, somebody is visiting from out of town, or they have to stay at a hotel in town because, like, maybe there's a water leak at their house or something like that. But it's intended as a temporary place. And in Georgia, for the first 90 days that someone stays at a hotel, the hotel has to pay kind of hotel taxes. But after 90 days, the hotel no longer has to pay those taxes. And so the argument is essentially, after 90 days, when the hotel is no longer paying those taxes, that resident is a tenant. And the court looked at some other factors as well. What were the intention of the parties? The hotel in this case advertised, like, stay for a night or stay forever, something to that effect, indicating that they knew that they were offering people a permanent residence, or at least a long-term residence. There were some ambiguities in the contracts that they signed with people about whether or not it was a tenancy or otherwise. So, and the court kind of decided, looked at those, the language there, and was like, this is ambiguous. But because Efficiency Lodge drafted the contract, they kind of said, well, those ambiguities are on you, so we're going to view them this way. Those were two of the main factors that they looked at, but also the 90 days. The Mr. Neeson and the other plaintiffs in the case were all long-term residents. They'd all been there at least a year or more. I think one of them was there for like 5 years. And the court was basically saying, they have personal belongings there. They've made it their home, and you can't just go in and throw them out. They're entitled to the protections under the Georgia landlord-tenant law. So things like they'll look at the amount of time, although that's not necessarily dispositive, because you can be a tenant, just being somewhere for a couple days, depending on the circumstances. They kind of look at the totality of the circumstances. But I think the main one being what was the intention of the parties when this all started, and also with hotels, where are we? Time comes into play more with the tax that has to be paid than with anything else. So right now, like I said, it's a little bit in limbo, but we are starting to see more and more extended stays, especially for long-term residents, filing eviction cases and offering, which has its complications too in terms of credit implications, but at least that offers the tenant the protections of a court process, time to figure out what they're going to do and secure their possessions so that they don't end up losing everything. And we have also noticed too that when extended stays try to do an illegal eviction and evict a resident, especially a long-term resident, without any kind of process, that local police are kind of willing to step in, like at least say you have to go through a court process, let this person back into their room. Which at the very least, even if the person is just like, I don't want to deal with them anymore, I want to leave, they can at least get their belongings and not be without everything. So, but in a lot of cases, what ends up happening is they get back into their room, and then the hotel basically files an eviction case. But at least, like I said, that gives some protections.
So Maggie, you've
Uh-huh.
seen that the police are pretty aware of this at
Yes.
this point?
Yes.
Okay.
I think there's variation depending on where you are, but at least the jurisdiction. I'm in Fulton County, so I primarily deal with the city and the northern suburbs, because our Clayton office usually does the southern suburbs. But at least the police jurisdictions that we deal with, and from what I've heard from other counties, is that most of them have been pretty good since this was decided about not allowing the hotels to move forward with an illegal eviction. Okay, so hopefully we'll have an update that we can share with you next summer about what the Supreme Court has decided. And then, because this is really about an injunction, they'll go back and do what we like to call the real litigation, which is discovery and maybe a trial. We'll see. I have a feeling, though, it might settle if depending on what the Supreme Court decides. So we'll see. You never know. Okay, so this is mostly kind of the advice that I give people during the tenancy.
Oh wait, Maggie, can we
yeah.
go back to that for 1 second? Because there was a question in the chat.
Sure.
So for the folks that are not considered tenancy,
Mhm.
can you just reiterate what the neighbor is looking at for that if they're not there for 90 days, if they
They're
don't
not
need
there.
that?
Yeah. So the court didn't completely hinge its decision on the 90 days. So it may be possible to still argue that someone who's been there for a short period of time is a tenant based on kind of when they moved in. Was there an intention to stay long term? Things like that. But it does become a little bit more difficult if there's still the hotel tax being paid. But we kind of try to look at the whole circumstance, because somebody who like just moved into, say, a rooming house or an apartment, if they've been there less than 90 days, is still clearly a tenant, because the intention was to be there for maybe a year or longer. But with the hotel, you just have the added complication of that hotel is still paying innkeeper taxes, basically hotel taxes for them. And so there's a stronger argument on the part of the extended stay that this person is not yet a tenant. But I think you could still make the argument. I think it would just be maybe a little bit harder.
So that's good advice for the folks calling in, that we can always say, well, we're not attorneys, but we do encourage you generally to, put forth that you intend to reside there, that this
Yeah.
is your residency. And that might work. That might give them some concern about just locking that door.
I would hope so, yeah.
Yeah. It may not work, but it's some, it's
I
an
mean,
argument to be made.
It's an argument to be made. It's worth a try. I mean, we certainly have times where someone is clearly in a landlord-tenant relationship where the landlord still tries to lock the door. So, you have a variety everywhere you go. But I think it's always worth trying, if for no other reason than it maybe gets them through the night and gets them the ability to get as much of their stuff as they can out of there. Assuming they have somewhere they can try to go. Which
Thank
I
you.
know is not a safe assumption, but
Yeah,
yeah.
thank you.
Okay. So like I said, like this is just kind of so the general information I give people during the course of their tenancy. Obviously, like I said, they may not have a written lease, but if they've got some kind of an agreement verbally, just try to follow those terms. Go refer to that if you've got questions. And one thing to note, so pets can be something that the landlord can say no pets or require a pet deposit. Service animals and support animals are not pets. They are sort of medically needed. And it's very clear under fair housing guidance that they should not be considered pets. There should be no pet deposit for them. And they cannot be prohibited by a landlord. A landlord can ask for some documentation about the need, but they can't really like demand specific details, but they can say, I really need a doctor's note, or I need something to show that this animal's had some training. But they are allowed, no matter the type of housing, they have to be allowed. Okay, so during the tenancy, the tenant has the right to use and possess the property. The landlord has given them that right. Well, the landlord certainly has some right of access, especially in terms of things like making repairs. Landlords should not be coming over to the property on a regular basis to do inspections or just to be there. They've given the tenant the right to use and enjoy that property, and they cannot interfere with that. If there is an issue where the landlord thinks that there's been a breach of the lease or some other reason, the landlord is required to go through a court process to evict the tenant. They cannot change the locks, disconnect the utilities, remove the doors and windows, do anything else to interfere with the tenant's right to use and possess the property unless and until the court has given them permission to evict the tenant.
And Maggie, there's a question that is in the chat about the last slide about guests, being careful with guests.
Oh, be careful with guests. This comes into play a lot in federal law, and so in subsidized housing, but it also will happen in just regular Georgia private landlord tenant. You are responsible for your guests' behavior, whether you know they're doing that or not. So if your guest comes over and is doing something that ultimately violates your lease, you could be evicted for their behavior, whether you were participating in it with them, whether you were aware that they were doing it. So I always tell people, your friends and family. If you have someone that you're worried about, maybe try to see them somewhere else, versus having them come on the property. And under federal law in particular, it can be even the Supreme Court case that kind of really went into this basically said, it was I think grandson came to visit his grandmother. He left her apartment. She thought he left the property, but then he went somewhere and got into some trouble, and she ended up getting evicted, even though she didn't know that he was even on the property anymore. And the Supreme Court upheld that. So you just have to be careful, because the conduct of a guest can get a tenant in trouble. In Georgia, there are really only 3 scenarios where a tenant can terminate the lease earlier than the end date of the term. Obviously, if it's a tenancy at will, the tenant can give notice. They don't have to have a reason. They can just say, I want to end this tenancy. And then in 30 days, the tenancy is done. If there's a provision in the lease that allows for an early termination, the tenant can do that. Usually those provisions include some penalties. They usually require a 60-day notice, that rent be paid during that 60 days, that an additional month of rent be paid, and that the tenant forfeit their deposit. So that can be pretty steep, but it is an option if a tenant needs to leave or wants to leave. Otherwise, federal law requires that if someone is an active duty service member and they're being deployed, that they be released from their lease where they are so that they can go without any kind of penalty for them or their family. And in Georgia, there's a law that says that a person fleeing domestic violence can give a notice. They usually have to provide either the criminal sort of stay away order or a protective order in civil court. But they can break their lease so that they can leave and kind of get to a place where their abuser can't locate them, hopefully. Those are kind of the ways under Georgia law that a tenant can break the lease. And obviously, I think usually an early termination provision in a lease will also allow a landlord to terminate early, maybe under slightly different circumstances, generally not as many penalties for the landlord, but there has to be a provision that allows that. Otherwise, the tenant is just as bound, the landlord is just as bound to the lease as the tenant is. The obligation to pay rent is separate from the obligation to make repairs in Georgia. So if the tenant has to pay rent, even if the landlord has failed to make repairs, which is sometimes a very hard thing to have to explain to tenants who are living in really horrible conditions. But Georgia law does not allow tenants to withhold their rent. If they do, an eviction can be filed against them. And yes, they can counterclaim for the failure to make repairs and the conditions issues and all of that. But the dispossessory or eviction court process is not really the best forum to raise those claims if you're a tenant. Generally, it's a very expedited process that's changed a little with the pandemic, but it is still generally a very expedited process. And it's not always easy for the tenants to get the evidence and everything that they need into court to prove their case under those circumstances. Whereas there may be other ways to get that information and to pursue claims outside of an eviction. Also, even if they do prevail on their counterclaims, they may still end up getting evicted, or an eviction case is still going to show up on their credit report. So I always advise people, like, I know it's unfair, but you still have to pay your rent. Landlords do have a duty to maintain and repair the property. They can't pass that off on the tenant. They can't say you rented this place as is. That does not exist in Georgia law. It does if you're buying a car, but not with rental property. But a tenant could potentially waive any claims that they have for damages if they continue to sign new leases knowing there are problems. That said, the landlord still is responsible for maintaining and repairing the property. Just because they haven't for 3 years and the tenant's been signing leases doesn't mean that they no longer have an obligation to make that repair. It just means the tenant may not be able to sue for damages related to that failure to make repair. Oops. Okay, so I advise people when, do we have a question, Mary Ellen?
Yeah, there's
Okay.
two questions actually, but
Okay.
I didn't know you were gonna keep doing repairs, so I can wait till they're both about
Okay.
repairs.
Oh, okay, all right, so hopefully I'll answer them, but if not, we'll circle back. So generally I advise people if they're calling us and something needs to be repaired, in addition to, I'm sorry to tell you, you have to pay rent, is that a paper trail is really, really important. So they should make sure, yes, they probably talk to their landlord, but they need to make sure that they've got written notice. This, though, is part of the reason why I love text messages. A lot of people have now, instead of calling their landlord, they're texting them. And that is written notice. I do always make sure though that I look at the text messages because sometimes they can be colorful. So it's kind of like, I know lawyers are weird because we look at everything and we're like, what if a judge was looking at this? And normal people don't do that. But I do try to make sure that I'm looking at it and thinking like, okay, if a judge was looking at this, is this clear? And also, is it free of profanity? But usually it's okay. But then I'll maybe ask them to follow up and say, well, send an email or do something, or I'll try to draft something and say like, hey, this person has contacted us and these are the things that need to be repaired. Could you please do that? Thank you. And then sort of starting that paper trail. I may try to also, I'll tell them to take pictures, but I may also try to go take pictures too. Just so that we've got kind of a record of what's been going on. I will advise my clients that they should try to work with the landlord to allow the landlord to be able to send folks to make repairs or come over themselves to look at things and make repairs. But that it is okay for the tenant, if someone shows up unexpectedly and says, I'm here to fix the HVAC unit, and the tenant is on their way to take the kids to school and then go to work, it's okay for the tenant to say, listen, today is not a good day. Could you come back tomorrow when I have a day off? Or could you come back, at 2 o'clock today when I'll be home? And kind of, work with the landlord and the person to allow access to make repairs. But you don't have to let somebody come into your house if you didn't know they were coming and you can't be there. Because that is the tenant's property and their things are in the house. If repairs are not made, there is the possibility of doing repair and deduct in Georgia. It's kind of complicated. It involves a lot of notice. And so I think if you've got somebody who maybe could do that, make sure that they give us a call so we can really walk them through it. The first thing I will tell people is if you've got a minor repair and you want to do a repair and deduct, that's fine. But don't do things like replace the HVAC unit or the water heater or other fixtures like that. First, because that's expensive. And second, that's a fixture. So it's going to stay with the house after you leave. And so you've just improved this property and you're not going to really get that. You're not going to get the return on it, the landlord is. And that's really ultimately the landlord's responsibility to fix those systems. If you own property, things like that have a lifetime limit. And the landlord really should be kind of making sure that they make those repairs. But they can do repair and deduct. But like I said, it requires, first, like, hey, this thing needs to be repaired. Please come fix it. And then, hey, I told you this thing needs to be repaired. You didn't come fix it. If you don't, this is what's going to happen. And then more notices after that. So really recommend that someone talk to a lawyer before they try that. Housing code enforcement is an option. I understand in Gwinnett, maybe not so much. Just recently learned that there may not be code enforcement in Gwinnett. But most counties or cities have a code enforcement unit that will come out and, maybe cite the landlord or maybe send them a warning letter. So that could be a way to either get the landlord to actually make the repairs or have good third-party evidence about the need for repairs. And then the tenant can also file a lawsuit to recover their damages. So they could file that in small claims court, which is the magistrate court, or they can file it at state or superior court, depending on how much they have in damages. They could, show the court like, here's my documentation of all the times that I've asked for repairs. Here's my photographs. Here were the medical issues we were having. Here's, which is why we went to the hotel. So here's the hotel bills, things like that. Or here's what I paid to make this repair. But also things like I, had to live with squirrels coming into my house all the time, and it terrified me and my child every day. And, that was stress and emotional damage and things like that. So they can sue for those kinds of things as well. It doesn't have to be like, here's my receipt. But it again kind of depends on what the circumstances are. Did I get to all the questions? Because this is kind of just a
Yeah,
lot.
there were two specific questions. So Charles worked with a client in North Georgia, and they were they are in subsidized Section 8 housing. And the management has maintenance coming constantly monthly to check on things. Is that excessive?
Yes. Georgia has some case law, but no like specific statute that says like kind of how where that line is. But I think like if there's no reason to be coming in, and a reason could be things like, there have been issues with the water heater, or there have been issues with the HVAC unit, and so we're coming in to make sure that it's still working properly. And so there's this specific reason, but really even after a few weeks, like if the tenant's not telling you there's a problem, you can stop. I think that is excessive. I think that's probably because I don't think they're coming in for a specific, we want to make sure the apartment's okay. It's more, you're a Section 8 tenant and we're suspicious of you for that. And I think that's interfere. I think it, a court might disagree, but I think that's excessive and interfering with the tenant's use and enjoyment of the property. To have someone essentially coming over saying, I don't trust you. I'm going to guess that they're not doing that for tenants that don't have vouchers. So, yeah.
Yes.
Yeah, and it's such the balance of power. So a lot of the things
When
that
did this begin?
they want to do.
Yeah,
let me
make
mute.
sure everybody's muting.
Okay, we're muted. So if a tenant does exert their rights, if they decline the maintenance check, if
Mhm.
they do, a repair and deduct, or if they call code enforcement,
Mhm.
what is your advice if the landlord seeks to get rid of them after that?
Yeah. And that actually brings us nicely into this page that I have up right now. That would be a retaliatory eviction.
Okay.
And there is a relatively new law in Georgia that prohibits that. Yay! And we have brought a few cases or raised counterclaims and some dispossessories based on that. And it basically just says, like, if a tenant is asserting their rights to have the landlord maintain and repair the property, the landlord can't say, well, I'm going to terminate your lease or increase your rent or file an eviction. The law does kind of do this weird, like within 3 months of them contacting code enforcement. And I, kind of, but it, 3 months is apparently a long enough time that we've had a number of landlords who don't wait, which was my initial concern. So I think if a landlord starts to make noises about, I'm gonna file an eviction, how dare you? It can be pointed out to them that that would be retaliatory under Georgia law, and they're not allowed to do that. And it has been a lot. And there are, in the law, there are penalties associated with the landlord if the court finds that they did in fact violate this law. I think the tenant generally gets maybe a month's rent plus $500, I think. So there are some penalties associated with it, not just you don't get to evict this tenant. There are other penalties.
And you can replicate.
And there's a couple other kind of terms that we use in here. The constructive eviction is basically if the place is so bad, either because the landlord has done something to make it so that's not livable, or by failing to maintain and repair the property, the place is unlivable, the tenant can claim that there's a constructive eviction and go. The trick with the constructive eviction is that you have to go. So a tenant can't just say this place is inhabitable, which it probably isn't, and then kind of stay there because they don't have anywhere else to go, which is a lot of our clients, unfortunately, kind of they're in a terrible place, but they don't really have anywhere else that they can go. And then an illegal eviction is when a landlord does something like changes the locks or shuts off the utilities, things that they're clearly not allowed to do because they do have to go through a court process.
So there's a question in the chat that might belong on this page.
Okay.
It is when a tenant has to leave because the landlord is doing repairs like a renovation. Is the landlord required to provide housing, or can the landlord charge them more if they're housing the tenant someplace else?
They shouldn't charge them more. If this is a landlord-driven move, even if it starts with the tenant has called code and code says you have to do this, that, and the other, and the landlord says, okay, well, the tenant is going to have to leave for 2 weeks. If the landlord sort of moves them into another unit, they shouldn't be charging them more for living in that unit for that period of time, or even if they just transfer them, like they shouldn't be penalizing the tenant. I think you could in some ways say that this is retaliatory if they're moving them to another unit, but increasing the rent. If the plan is to relocate the tenant to a hotel, I do think the landlord should be putting the bill for that hotel but for their failure to repair, the tenant wouldn't have to be there. But you might have to argue that one in court. But yeah, I think if it's a landlord driven, either based on their failure to repair, or they've decided that they're going to be renovating units and they've gotten to this building and there are tenants in there, once again, this is a landlord driven decision. The tenants should not be penalized because they have to pick up and move because the landlord has decided to renovate those units. Now, when they get to the end of their lease and they're looking at renewing and they're now in a renovated unit that the landlord is charging $500 more a month for, unfortunately, there's no, the landlord can say, you can renew your lease and sign a new lease with us, but the rent is going up to that amount. But they shouldn't be doing it in the middle of the lease term.
Thank you.
Okay. Okay, so as I've said, the eviction court process is required by Georgia law. Landlords have to complete the entire process to lawfully evict a tenant. We will see sometimes the landlords get close, but they don't quite finish the whole process, and that is still an illegal eviction. It's also important, once a court case has been filed, to make sure that the court knows what's going on between the parties. So the landlord and the tenant may be talking to each other, and that's great. If they want to work something out, wonderful. They need to make sure that the court knows what's going on. And in most cases, it's especially important for the tenant that the court knows what's going on. So I always advise people, like, if you and your landlord come to an agreement, just make sure you put it in writing and file it with the court. Or if, even if you don't do that, make sure that you maybe draft a letter and say, we came to this agreement, they agreed to take the money and dismiss this. Here's the proof that I've made the payment. Please dismiss this case. And just kind of make sure that the court knows that this case is resolved and should not move forward with any kind of an eviction. And then at the end, as I put here, there are no more moratoriums. All of the federal moratoriums and even the state moratoriums related to the pandemic have long since expired. So basically at this point, it's just a question of how quickly the courts are processing eviction cases. And we are seeing really high numbers of cases being filed. So okay, so an eviction can be filed for any breach of the lease term or tenancy, or at the end of the tenancy. The only thing that is required under Georgia law before an eviction is filed is that the landlord demand possession. That does not necessarily have to be in writing. It doesn't really even necessarily have to be specific. We once had a landlord who typed "get out" with an exclamation point and blew up the font so it filled the whole page and gave that to their tenant. That is a valid demand for possession. They don't even need to type it out. They could have just gone to the house and said it, and that would have been a valid demand for possession. If they do give a notice that says you owe this much in rent and you have till Friday to pay it, then the landlord has to wait until after Friday to file the eviction. They've given the tenant an opportunity to cure. They have to wait until that period ends. But if a landlord just says, your rent was due yesterday, you didn't pay it, pay me now or get out, and the tenant doesn't pay, they can immediately go down to the court and file an eviction. They don't have to give any other notice. As I said, it's the county where the property is located, where they file. Usually in magistrate court, they could file it in state court, but most of the time these are filed in magistrate court. It is an expedited process. Generally, it moves very fast. Pre-pandemic, an eviction filing to the court hearing, generally a month, maybe less, depending on how quickly people get served. The courts, some of them don't have any backlog at all. They were just having hearings. Fulton still has a bit of a backlog. I think some of the other metro counties do, but other counties are processing these cases like there's been no pandemic, basically. So this is the Fulton County form for a dispossessory warrant. They usually have the case number will be up at the top. It'll kind of give you information in the middle there about why it's been filed. As you can see, it doesn't have to give a lot of information, just failed to pay rent, lease ended. The two main areas, if somebody gets, and in the counties, each county I think has a slight variation on this, but they're generally very similar. The main areas are under the summons part. That's where it says where to go to file the answer. And at the bottom, it has the date that the person was served and the date that their answer is due will be written there. Those are kind of the key sections that I make sure people look at. In Fulton, they can file in person at the courthouse or they can go online. There have been some issues with the online system, so I advise people very strongly to go in person. If they're in North Fulton or South Fulton, and getting to the courthouse is not an easy thing. There are annexes. I think in South Fulton, I think it's on Stonewall Tell, and in North Fulton, it's on Roswell Road in Sandy Springs. They can go file their answers there. And then they can make sure that it's filed into the case without any issues. Service of this could be personal, which is basically just, it can be handed to someone. Notorious is when it's handed to someone who lives in the property, but is not necessarily the named defendant. That could be someone who's considered of suitable age. So it could be a teenager. Can't be like a little kid, but could be a relatively young teenager. My niece is 14 and I'm like, I wouldn't want someone handing something to her. I might not get it. But they could give it to her. But it does have to be someone who lives there. So if I'm visiting my brother and someone serves them with a dispensary warrant, if they give it to me, he could say that's not valid service because that person that you handed it to doesn't live here. Most people, though, are served by what's called tack and mail, which is where a copy of the warrant is put on the door and then a copy of it is mailed to the address. The mailing has to be the same day as the tacking. If it's not, then the tenant can challenge service and say basically service wasn't proper. Even if they haven't gotten the mailed copy and the answer is due, I will advise them to go ahead and put that in there, because if they don't, they can't bring that later. Most of the defenses or counterclaims you can amend to bring them later, anytime up before the hearing, but service has to be raised immediately. If they do get it in the mail and the postmark is a different date, then they need to save the envelope. That is very helpful. If there's no answer filed when they are served by tack and mail, the landlord will be entitled to possession, but not a money judgment. So sometimes if we have someone who is in the process of moving out or is mostly moved out and just went back to kind of check on a couple things or get the last of their stuff, and they found the warrant on the door, we may advise them to just go ahead, ignore it, don't file an answer, just leave. Because the landlord is only going to get possession of the property. They won't get any kind of a money judgment against the tenant. But obviously somebody who's staying in the house should go ahead and file an answer. And this is just the answer form for dispossessories. And I'll get into some of the defenses and stuff later. Ooh, we're running late. I'm sorry. Just realized what time
This is very good information. So
Okay.
if people can drop off and know that it's being recorded, but if you have time to keep going, then please do.
I apologize.
No, it's great. Thank you.
I thought it was going fast, but apparently not. So the tenant should check off anything that applies in terms of a defense. They can raise their counterclaims that they have against the landlord. If they're not sure how much they want a counterclaim for, they can just write in an amount to be determined at trial or TBD. I always advise people at the very least check that my landlord terminated my lease without a valid reason, so that you're at least telling the court, I'm disputing that they have the right to evict me. You don't have to go into all the details of everything in the answer. They can get into more specifics when they get to the hearing, but they just have to say something. At the bottom of this form, it still has the, hearing date and time information. In Fulton County, they used to be able to tell you right when you filed your answer, when your hearing is going to be. They don't do that anymore. They will send you a notice in the mail of the date, with the date and time of the hearing. But other counties may be at a point where they're still able to do that if they don't have as much of a backlog. Pre-pandemic, the hearing would be 1 to 2 weeks from the day the answer was filed. Now it's taking a little longer in Fulton. So it's a little harder to predict. I used to be able to be really good at predicting it. They've taken away my magic talent. Anyway, the answer is due within 7 days of the date of service. And so, like I said, on all of the warrants, it will say at the bottom, date of service, date the answer is due. If that 7th day is a holiday, they should write down the next day. So like if you're served on the Monday before Memorial Day, court is closed on Memorial Day, the date that's on there should be the Tuesday. But they do have until that next business day to file the answer. The named defendant or defendants must file the answer. So if it's landlord versus tenant A and tenant B, tenant A and tenant B should file answers. They can either file a joint answer that they both sign, or they can file 2 separate answers if they want, but they should each file an answer. So raise any defenses, raise any counterclaims. If no answer is filed, a default judgment will be entered against the tenant. If there was personal service, that will include a money judgment. But either way, it will allow the landlord to move forward immediately with an eviction. Well, they can immediately file for a writ of possession to evict the tenant. So even if the tenant is applying for rental assistance, even if they are making payments to the landlord, even if they're talking to the landlord, trying to work out some kind of an agreement to resolve it, they still should file an answer to protect their rights, to let the court know, hey, we're working on this. If they don't file an answer, they're not going to get a hearing, and the landlord could move forward with an eviction. Even if they're talking to the tenant about trying to resolve it, they could still move forward with the eviction. So the tenant needs to make sure that they file an answer so that they protect their rights and they can get to a hearing and have more of an opportunity to remain housed while they're trying to work things out with the landlord. In Fulton, there's sort of a formal mediation process, but it is optional. Both parties have to agree to it. In a lot of counties, they will just kind of say, why don't you guys go out in the hall and talk to each other? That's fine. Parties obviously also can talk before court and try to work out the difference. The main thing to know is if the parties come to an agreement in mediation, or they come to an agreement outside of court and they put that in writing and both sign it and file it with the court, that is binding. There's no going back later and trying to appeal it. If the parties agree to change it, they can do that. But if the tenant agreed to move out by a certain date and now they want more time, unless the landlord agrees to give them more time, there's nothing that the court can do to kind of undo that agreement. If they go to the hearing, obviously both sides get to present documents, witnesses, anything they want to support their case. Tenant can both bring information about the defenses they have to the landlord's claim and any evidence that they have related to their counterclaims. Most of the time, the judge makes a decision there in the courtroom. It will be put in writing and there will be a written judgment, but sometimes they often will just tell you from the bench what they're going to do. Sometimes they'll take it under advisement and you get the written decision within a couple of days. If the tenant fails to appear, landlord is automatically entitled to a default judgment or both a money judgment and possession. If the landlord fails to appear, The tenant, the case should be dismissed, but if the tenant has raised counterclaims, they can either choose to say, I'm going to dismiss my counterclaims, or they can say, I'd like to have a hearing on the counterclaims and go ahead and present their evidence to the judge. It'll be up to them. There is a provision in the law about if a case has to be reset, or if you can't determine within 2 weeks how this case is going to be resolved, that the tenant should be paying rent into court. That's still there, but it hasn't really been enforced, at least not in Fulton County, during the pandemic. But I do just kind of want to make people aware. It's something that could come up. So, like I said, these are some common defenses that we'll see. I do want to make one note about bankruptcy. So if someone files for bankruptcy and they have a pending eviction and they include the landlord and the eviction in that bankruptcy, the automatic stay will apply. They do need to make sure they let the court know. They'll get a notice of the stay and they can file that with the court. But that stay can be lifted very easily as soon as next month's rent comes due. So if let's say I haven't paid rent this year, for various reasons. I've been working, been sick, and my landlord has filed an eviction, and we're going to court, and I file a bankruptcy, and I file the notice of stay in the bankruptcy today, because I filed the bankruptcy this week. That would include the back rent that I owe through this month. As soon as we get to January, that's a new month. New month isn't included in the bankruptcy. So if I don't pay January, landlord can go to the bankruptcy court and say, could you lift this stay? Court generally will do that, and then can go back to the eviction court and say, okay, yes, December and earlier is off the table, but she owes later accruing rent. So bankruptcy can be helpful in some situations, but is not necessarily going to, it may just delay an eviction for non-payment and not necessarily stop it. And like I said, some common counterclaims that will come up. The vast majority of time when we're looking at counterclaims, it's related to a failure to maintain and repair the premises and the damages that come from that. But sometimes, the illegal eviction and things like that. Okay. If there's a hearing and you're a magistrate court and either party disagrees with the judge's decision, they can file an appeal within 7 days from the date the judgment is entered, which is usually the day of court. There are generally costs associated with that appeal. If they're not paid timely, the appeal will be dismissed. The other thing that tenants need to be aware of is that their rent will need to be paid into court pending the outcome of that appeal. So that will include any past due rent amount that the court finds is owed. That has to be paid basically by the appeal deadline into the registry of the court. And then ongoing rent will have to be paid each month thereafter. So January rent would have to be paid by like January 5th into the registry of the court, and so on and so forth, in order for the tenant to stay in the property while the case is pending on appeal. So if the rent isn't paid, the appeal might continue, but the landlord could still pursue the writ of possession and evict the tenant. And obviously this is generally can be an issue for tenants, but obviously these days where sometimes it's been several months since the case has been filed, the tenant owes thousands of dollars, and they don't have that kind of money to be able to pay to the registry of the court to stay after the hearing. So if there's no appeal, or if the rent isn't paid on the appeal, the landlord has to complete this last step. They have to go down to the court and get a writ of possession. In Fulton, they apply for it, a judge reviews it, they'll sign off on it. And then it goes to the marshals. The landlord and the marshals kind of coordinate, and the marshals come out and kind of monitor while the writ is being executed and the tenant is being evicted. Generally, the marshals do not tell people when they're coming. Even if you call them, they're not going to tell you when they're coming. Lately in Fulton County, they have, because it's generally there's a longer time period than there has been in the past between when a writ is applied for and when they're actually able to execute it, because they also have a backlog and can only go to so many places over the course of a day. They have been coming out and putting notices on people's doors to let them know that the eviction is coming within the next few days. That's not required. They've just been doing that. I hope they continue to do it. But there's nothing that requires them to do that. So I tell people this may happen, but you should still generally expect, once the landlord is allowed to have a writ of possession, that an eviction could be coming at any time. And to make sure that they're keeping their, especially anything that's an important paperwork, medications, things like that, in a place where it'll be safe if an eviction happens. Okay, only a couple more things. At the end of a tenancy, if a tenant is moving out, they should make sure they give proper notice. Don't just assume because the lease is ending that the landlord necessarily expects that you're going to be moving out. Make sure you give a proper notice, return the keys, and either try to do a move out inspection with the landlord and or take pictures or a video so you've got a record of what the place looked like when you left. Landlords have 30 days from the date that possession is returned to either return the deposit, return part of the deposit and explain why they kept the rest, or keep all of the deposit and send something explaining why they've kept it. That notice also, or the deposit, needs to be sent to the tenant's last known address. So the tenant either needs to make sure that they give a good address, whether it's the place that they're going or their mom's house, up to them. And they should probably also have their mail forwarded just to make sure that they get anything. Deposit can only be kept for normal wear and tear or for money that is owed. It can't, and normal wear and tear kind of is a, it's one of those, you know it when you see it kind of things, but it depends on kind of how long the person lived there and what you would expect, right? If someone was there for 20 years, then of course you're going to have to replace the carpet. But if someone was there for 6 months and there's, you know, Kool-Aid stains all over the carpet, that's a different issue. One thing to be aware of, if a tenant gets a partial deposit back and they want to dispute the landlord's decision to keep the rest of the deposit, they cannot cash the check. Under Georgia law, if you get, you know, 500 of your $1,000 deposit back and you cash the check, the law considers that to be what's called accord and satisfaction. Essentially, you've agreed that that's all you're entitled to get back, and you can't try to get the rest of it. So if they want to dispute it, they should, actually they need to send it back, but they should send it back with a demand letter. So if you've got someone in that situation, please try to get them to an attorney so that they can talk about their options and see if someone can help them with a demand letter and or with a lawsuit if they need to. Okay, I'm gonna just leave this screen up and then go back to Mariel and say, does anybody have any other questions?
Yeah, we do have some good questions.
Okay.
So the first one actually relates to a transitional housing program.
Okay.
So one of the conferences has a transitional housing program, and they have their participants sign an agreement that says, I'm not a tenant, I am a program participant.
Mhm.
And there are rules and such. What ability do they have to kick someone out if they're not following program rules or if, you know, for another reason?
I think, well, some of that is going to depend on the exact terms of the agreement and how specific those terms are. I think generally transitional housing, and you might actually be able to speak to this better than I could, Maria. Transitional housing generally, I think, is not considered a landlord-tenant relationship. There might be some exceptions if it's actually set up like an apartment complex and the tenants are paying rent and things like that. But I think a lot of places that are considered more transitional, maybe like some kind of rehab program or something like that, where the person is only supposed to be there for a short period of time and there are specific rules and all of that, those would not necessarily be covered by be considered a landlord-tenant relationship.
So it's okay to say, I need you to gather your stuff and I'm gonna walk you out. That's permissible for a
Generally,
program.
yes. And
That was my understanding too. That's how it's
yeah,
been in the
generally
past.
speaking, you know, like I said, like
Yeah.
some transitional housings are set up a little bit more like a longer term and they have people living in kind of apartment style. And I think in those situations, there might be an argument that that's become a tenancy, but most transitional housing programs are not considered
Yeah.
landlord-tenant. And it is okay to say, you know, you violated, here's the agreement, here's the, you know, the process. You violated the rules, you know, too many times. You need to gather your stuff and go.
And it could even be spelled out in that agreement that if, you know, if the program directors find a violation, that this will
Mhm.
be the protocol of
Yes.
immediate,
Yeah, and in fact,
yeah.
I would recommend that. And obviously, you don't, you want to leave, you know, you may want to leave some room for things that you haven't thought of before, because there's always going to be that situation. But
Yeah.
I think it might be good to have some specificity, like this is what happens if the rules are violated, and here's the steps that we'll take, and blah, blah, blah.
Yeah, that is wise.
Mhm.
Okay, thank you for that. Speaking of leases, there's a fellow in the chat who is noticing that in Georgia there are less protections for tenants than in other states,
Yes.
and the leases tend to have, you know, an imbalance of power
Yes.
against the tenants. Do you have any recommended sources of template leases that landlords can use that are better than the ones that some of the tenants we you know are currently in use? Are there any recommended templates?
Not that I know
Okay.
of.
Okay.
There may be on trying to think, like if Georgia Legal Aid has anything. I don't think Georgia Legal Aid even has like a template like that. But yeah, there's
You could take from another state and just change it
you
all
could
to
do
Georgia.
that. You could do that and kind
Yeah.
of make some modifications. Like there would be no reason to not do that.
Yes.
Yeah.
Yeah. And that leads into the next question, which is a lot of folks are seeing on their lease renewal, their rent, you know, I'm not going to say doubling, but in some case it might even be
Close.
doubling or
Yeah.
close to doubling.
Yeah.
What advice can you give to these caseworkers when they have people coming in and saying, I can't afford my next renewal of my lease?
I wish I had good good advice related to that. Georgia does not have any rent control. In fact, it has kind of the opposite, where it doesn't allow it at all. And affordable housing is harder and harder to find. And also what's considered affordable is becoming more and more expensive as everything else increases. And I wish I had, you know, some kind of way to resolve that.
Yeah.
Depending on how long the tenant has been there and what kind of relationship they have with the landlord, maybe they could try to negotiate something, but it's bad all over right now in terms of how the rents are just skyrocketing everywhere. And I don't there's really nothing right now in Georgia law that kind of offers
That
any
offers a
protection.
protection. I think that goes back to the question from Mr. Lurch or Miss Lurch. I look forward to meeting you. I think it goes back to them because they're saying, where's a good lease? And a landlord could put in their lease that it won't go up more than X percentage
Yes.
upon renewal, but that would be on the landlord's
Yes, it would.
lease. It would be their discretion in Georgia.
Yes.
Mariel,
Yeah.
Mrs. Lurch is me, Javier, okay?
Ah, okay.
All right. So one of the things I want to ask Maggie is, can legal aid help us to write a decent standard template contract that we can share with our with our landlords? We especially get really bad contracts when we have landlords that are out of state from California, okay?
Oh,
And some of the clauses are just, to me, as a naive person, completely illegal, okay?
mhm.
And I would like to go and tell them, hey, what you're using seems very bad, but let me give you something that I think is fair, okay?
That is something I have to check with a couple of folks higher up about, but that does seem like even if we can't work directly with someone, maybe worth having something that's available. But let me check with some folks and I'll get back to Mariel so she can get back to you.
Yeah, that would be great. That would be great.
Mhm.
And okay, 2 more questions. So the next one is for someone who had to leave. So I'll email your response to him. But does legal aid help with any of the follow-up when people have applied for rental assistance and they don't know if they're going to get the funds, with accountability for that?
We have been trying to do that in a number of cases. We've run into similar frustrations, but we have a couple of avenues where we have gotten some responses sometimes. But yeah, that is something that we will, if someone contacts us, we do advise them to, obviously make sure they're keeping an eye on the portal. But we will try to reach out to Georgia Rental Assistance and see if we can try to help expedite something or help get more information to them if that's what they need, to try to get those application processes going.
So that
And
is
Georgia
great.
Legal Services, I believe, does as well.
So I'll send out the contact information for Georgia Legal Services Program, which is for outside of the metro area. And then that's great. That is great that you all are able to do that.
Or at least that we try to do.
Sure, sure. I know you know Elizabeth
Apple.
Apley. She was working with someone and she didn't have success
Mhm.
and they ended up getting evicted. And
Yeah.
she's very well connected. So
Yes.
you can only do what you
And
can do.
very tenacious too.
Very tenacious.
But
Yeah.
we will definitely try on behalf of folks.
Yeah. There's a great question here from Francis. How long does an eviction stay on a tenant's record?
Hmm.
What rights do they have when trying to get another apartment?
Generally speaking, 7 years is how long things will stay on someone's credit report. What information is on there can vary a little bit from tenant to tenant. Generally, in the public records section, if an eviction case has been filed, just the fact that a case has been filed will show up there. If there was a judgment or a debt owed to the landlord, that could also show up, in the kind of the debts section. If the first thing that tenants can do is make sure that they're getting their credit report every year. They can go to annualcreditreport.com. They can either do it online or there's a form that they can download, or if people call us and they need it, we'll send it to them to get their credit report every year. The first thing that they can do is just make sure that the information is accurate. So yes, an eviction case may have been filed, but it was dismissed and it should show that. Or they reached a consent agreement, should show that. The amount of the debt that's owed, if there was a judgment, they should make sure that that is accurately being reported, and they can dispute the information through the credit reporting agency if it's inaccurate in some way. Or if they disagree with it and they're like, hey, send me information because I don't know what you're talking about. They can do that as well, because sometimes evictions are filed after people have left. They're like, wait a minute, I didn't know anything about this. In some circumstances, they can ask the court to seal the record. It's going to vary from court to court whether they're going to be willing to do this. In Fulton, they have been in some cases, but we've had to show, well, one, obviously that it's causing a problem for this person, because court records, the reason they show up is that they're considered public because there's a public interest in just knowing what's going on in the courts. So you have to kind of show that the privacy concern outweighs the public interest, which is kind of this nebulous thing, but you still have to show it. Then we have to kind of show that there really wasn't a reason to file this. So it's not just, they're not just going to grant it for, yeah, I owed money, but I paid it and now I don't owe any money. Like they're still going to say, yeah, but you did. But we will have it. Sometimes we've been able to get them sealed for folks who, like, they never owed the money. There was maybe an issue with bank or something like that, but they had paid timely, and so it never should have been filed. Or they moved out before this was ever filed, and the landlord knew that, but they still filed it anyway. We've been sometimes able to get stuff sealed that way. We had a couple of cases too where, like, the person wasn't actually on the lease, and they somehow got, like, wrapped up in the eviction, and kind of gotten it expunged as to them, to try to help with their housing search. But it's becoming more and more of an issue for folks because, unfortunately, really the only thing that they can do is just make sure that the information is accurate and try to get ahead of it by saying to prospective landlords, I had, I lost my job in the pandemic and I had an issue at that time, but since then the rent has been paid, the debt has been paid. I went on and continued to live there, or I moved out and made sure that debt was paid off, and now I'm back on my feet, and hope that people are understanding of that. There was some talk of maybe trying to look at cases that were filed at the height of the pandemic in like 2020 and 2021, and see if there was some way to do to seal cases that were really very much pandemic related, but that hasn't, as far as I know, gotten a whole lot of traction. So hopefully something like that though could happen, which would help a lot of people out.
Absolutely. Okay, so that was a very very helpful and comprehensive webinar for us. I so appreciate everything you've taught us today.
Thank you for having me.
Yeah, I think you covered it all.
Sorry about that. Took a little longer than I anticipated, but
Well, it's important information to have. And Housing Day at the Capitol is coming up on February 22nd. It's in the morning where they talk to us about, the different conversations to have with your legislator. And then you go across the street. If I don't know where we'll be, it's usually across the street. Maybe we'll start out in the Capitol this upcoming year, though. And then you go and you talk with the legislator that represents you, and you tell them, this is what's going on, and I would love for landlords to, X, Y, and Z have to accept payment instead of filing an eviction. That's something, there's only 7 other states in Georgia that don't require a period of time for a tenant to cure, to allow them to pay the debt and to pay, you know, whatever fees are owed. That would be really changing for Georgia to have. So things like that will be discussed at Housing Day. And I'm seeing a lot of thank yous in the chat. So yes, thank you so much. And thank you to everyone who joined. We'll send out an email. I'll find out if Maggie can share her PDF. I'll send you the, thank you. I'll send you the contact information for outside of the metro area. And thank you all for the work that you guys are doing with neighbors, that you do so well. So thank you for that. And the recording will be somewhere on the member website, and it will be emailed to you. So thank you all so much. And it's actually a nice day today.
No.
It's cold, but I'm looking out the window and I see some
The sun is out, so
The sun is
I'll
out.
take any temperature with the sun being out right now.
So yes, so that is absolutely lovely. So everyone go take on the day, and we will be in touch. Thank you all so much.
Thank you, everyone. Thank you, Mariel. Nice to
Thank
see
you,
you.
Maggie. It's so good to see you. Thank you.
Bye.
Bye-bye.